Hail to legal warriors. In this video, I'm going to cover what you need to know in case you're facing a second offense DUI in Washington State. It's not hopeless, but we have to be very careful, and I want to go over your options and what is some of the best things that we can do to help ourselves if we're facing this situation. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get to see it, and they'll get the help they need. Now, I'm just going to jump right into it. This video is not about a first offense DUI in Washington. It's not about a third offense DUI in Washington. It's about second offense DUI. And let's hope you're not in this situation. But I'm going to cover what you need to know if you are in the situation or someone you care about is in the situation. So first of all, let's define what the law means by second offense. It does not mean second lifetime DUI. It's a term of art as defined in the law. In the law, DUIs are penalized at a greater level, more of them that we have. And a first offense DUI is what it sounds like, a DUI, the first time you ever got one, okay? A second offense DUI means a second offense within 7 years of the first offense. And it doesn't just count deferred. Let's say your first offense was reduced to reckless driving, or your first offense was reduced to negligent driving first degree, or even your first offense was dismissed through successful completion of deferred prosecution. Well, even a reduced DUI or a dismissed DUI through deferred prosecution still counts as a prior offense, making a second charge within 7 years your second offense. But Lance, I didn't get convicted of DUI the first time. That's true, but a prior offense under the law is a term of art. Prior offense counts a reduced to reckless, a reduced to neg driving first degree, or dismissed through deferred prosecution, not through an SOC, stipulated order of continuance, but deferred prosecution. So if you've had a prior reduction or a prior dismissal through deferred prosecution, you're looking at a second offense DUI if this new DUI charge happens within 7 years of the offense date of the other DUI, not the date you resolved it. So let's say you had an offense date of February 1st, 2022, and you're resolved it on October 1st, 2022. When does the 7 years start? October 1st, 2022, or on February 1st? It starts on February 1st, 2022. So if you get to February 2nd, 2029, now you're back to a first offense as of that date. You don't have to get to October 2nd in this hypothetical. It's February 2nd. And that doesn't mean that the court and the prosecutor won't consider your first offense in that point, but it counts as a first for the mandatory minimums. So I know that's a bit confusing, but that's how we calculate whether or not you're looking at a first offense or a second offense. Does the prior offense count as a prior offense, even a reduction? And is the new one within the offense date of the new charge within 7 years of the offense date of the other charge, not the resolution date, not the time you resolve the new case, arrest date to arrest date, offense date to offense date. So what are the penalties? Why do we care about a second offense DUI? So RCW 46.61.5055 lists the penalty schedule as it exists at the time of putting out this video. I'm filming this in December 2023. And so if it's a couple years after that, take a look at RCW 46.61.5055. We're going to link to it in the description, so you can see what the penalties are. But it lays it out pretty clearly. You'll see in bold, no prior offenses, a certain type of penalty schedule. One prior offense, certain type of penalty schedule. Two or more prior offenses, another type of penalty schedule. So we're in the second offense. So we're talking one prior offense. Then it breaks down the penalties into whether or not we had a certain level of breath test. If we had a breath test under a 0.15, or there was no breath test, but not because of refusal, there's a certain level of penalty. And then there's aggravated penalties if we blow 1.5 or higher, or we refuse a breath test. So I'll just go the short version of this. If it's a second offense and we blew under 015 or there's no test and not because of refusal, the mandatory minimum penalty is 30 days in jail, followed by 60 days of home detention after we do the jail time. If we have that enhanced penalty, 0.15 or above, or a refusal, we're looking at 45 days in jail minimum, followed by 90 days of home detention afterwards. So we're talking serious jail time. Now remember, if we do a 30-day sentence, most jails are going to give us a third off for good time. So 30 days equals 20, but that's still a lot of time. And typically speaking, you do not get good time off of home detention. Although you might want to ask your attorney if you're being found guilty of this. Some courts will convert your home detention time into straight jail time at a 15-to-1 ratio. So if you had to do 30 days in jail plus 60 home detention, some courts would convert the 60 home detention into 4 days of straight jail. And I would rather do 34 days minus a third, right, than 30 days minus a third plus another 60 wearing a bracelet where I can't leave my house except to go to work, okay? So that's something to ask your attorney about how the court is that you're in handles it. Same thing goes if you're above a 1.5. Additionally, if you're convicted, there's going to be certain types of license suspensions based upon what's happened to you in the past. I'm not going to cover how much suspension, but it's going to be substantial. There's also going to be a certain amount of ignition interlock requirement, okay? If we have a prior interlock restriction, because we were actually convicted of the first DUI and we had a 1-year restriction that time, if we get convicted of another DUI, it's a 5-year restriction for the interlock at the time of filming this at least. So it's a pretty serious penalty. So is all hope lost? No, it's important to realize that a second offense DUI is on the fact patterns just as defendable as the first offense DUI if there are legal problems. If there are legal problems on a second offense, it's going to be the same problems that we'd see on a first offense. What are those legal problems? What might they be? How might an attorney be able to defend a second offense DUI? I like to think about it as either bad cop or bad stop. Okay, that's the way I think about it. What's a bad cop? Bad cop is someone who didn't do the field sobriety test instructions correctly, right? Bad cop is someone who didn't do the breath testing observation period correctly, didn't score field sobriety tests correctly, did things that calls into question their testimony. What's bad stop? Then what it sounds like. What was the reason for the officer to pull over the vehicle? Was there a valid reason? Weaving within the lane without crossing the skip lines, basically the lane markers, very well may not be a good enough reason to pull someone over in Washington State. That's going to be subject to testimony and motions. Additionally, if another person calls in your vehicle, how reliable is that complaining witness? Did they make a conclusion about the driving? I saw a drunk. Well, that's a conclusion. It's not objective. An officer's going to need to establish their own reason to pull over a vehicle in most cases if they only have a conclusion from a 911 call. The 911 call says, yeah, I saw them drive on the shoulder. Well, now the officer probably doesn't need his own reason because driving on the shoulder would be in and of itself most of the time illegal, and that could very well, under the Washington case law, give the officer a reason to pull you over. But think about it. Your attorney is going to look at bad cop. What did they do wrong? Bad stop. What were the reasons for stopping the vehicle? And were they entitled to continue on with the detention or not? That's beyond the scope of this video, but there are legal ways to defend the case. Well, how come it's so much harder to get a second offense reduced off a DUI than a first offense? Well, it's because prosecutors typically are only going to reduce first offenses. It's mainly for caseload reasons, right? They don't have the time to take everyone to trial. And so in a first offense, they can be a little more forgiving. They're not going to forgive us, but a little more forgiving and give people some benefit of the doubt if it's a first offense and look at legal arguments with a less critical eye. Once we get to a second offense, you've already had your bite at the apple. There's going to be more consequences to them if they let someone go on a second offense without a very serious legal problem. And therefore, it is harder to get out of or to get a reduction on because the person who makes those decisions typically is the prosecutor, not the judge. The bad news about DUI case law in Washington State is there's no advocates, of course, for DUI drivers. There's no equivalent to Mothers Against Drunk Driving or other groups that are rightfully pressuring the legislature to make things difficult on people that endanger others on the road. And therefore, the case law also comes down extremely against people accused of DUI. So there has to be other ways to help eliminate or avoid jail time in a second offense DUI. And the main way most people do it, and something you should think about, is something called deferred prosecution. Now, we have a couple other videos, at least one other video on deferred prosecution, and I'm going to have my team put that somewhere in this video, hopefully right about now, but I don't do the editing of these. But you can watch that video if you want a lot of detail, but I'll go into it shortly here. Deferred prosecution is a statutory creation under RCW 10.05 is the whole statute. Basically, it says if there's in this case, let's only talk about DUIs. In the case of a DUI, if an alcohol and drug evaluation agency makes certain findings that the driver needs a certain amount of treatment, typically a 2-year treatment program, and they make certain findings, the driver can do the 2-year treatment program and stay out of trouble for 5 years with no new crimes, don't consume alcohol, drugs, or other stuff. And at the end of 5 years, we're going to give you a reward. We're going to dismiss the case. No jail time. It beats a lot of the suspensions, not all of it. Doesn't beat a refusal suspension on the administrative side, but if you took a breath test, it beats all the suspensions. You only get court costs. You don't get fines. You don't go to jail. You do get an interlock requirement. So if your first DUI was a conviction of DUI, if you enter deferred prosecution, you're going to be back at that 5-year interlock. If the first DUI was a reduction, you're going to be at a 1-year interlock. It could also have some effect on your firearm rights. A conviction of DUI, second offense, or the deferred prosecution can have an effect on your firearm right. That's a new law. Went into effect a couple of months ago. It has nothing to do with whether or not you have a gun in the car. It's sort of nonsense to me, and we'll see if it stands up. But at least ask your attorney to see if that's the status of the law. Hopefully it's not if you're going through this, but if you care about guns, make sure you know that. But so there's a lot of benefit to the deferred prosecution. It's hard to get through, but if you get through it, not only do you get the benefit of your case getting dismissed, you probably are also able to greatly tackle whatever alcohol and drug issue has got you into the second offense DUI situation. So if there are some legal issues with the case and you don't want to use that deferred prosecution, you can only do once in a lifetime, your attorney may be able to have you do a lesser amount of treatment and use your success in treatment along with the legal issues to try to get another reduction in the case. There could be a fatal legal flaw to the case that could make the case go away. Those are fewer and far between. But your experienced attorney is going to be able to look at how the breath test was performed. They're going to be able to hopefully get a video of the breath test room and see if the officer followed the instructions. Nowadays, officers often have lapel mics or cameras so we can actually see what the officer did or didn't do correctly, so we don't need to rely on the testimony of the person who's been drinking. And there may be certain medical reasons why you couldn't do the field sobriety test. We might be able to show those and therefore call into question the reason why the officer made the arrest and sort of turn that good cop into a bad cop because they made assumptions and didn't listen to you about your back problem or your leg problem, whatever it is that might explain worse results on a field sobriety test than drinking. So if you've got that second offense DUI, realize you have to take it seriously. You have to get a really good attorney, and you have to do what the attorney says. Okay, it's most important that you do what the attorney says. We're not going to panic. Okay, there's a way out typically for deferred prosecution if you weren't foolish enough to use it on your first offense. Hopefully that isn't what you did. For some people it's not foolish, but in our opinion it usually is. We want to save that deferred prosecution. So we don't want to panic, but we do want to take appropriate action. If you've got a state case, you're not going to have a court date right away. You still need to then request that DOL hearing, Department of Licensing hearing, within 7 days of the date of the stop. If you had a breath test that was above the limit, or you refused, or you had a blood draw above the limit for certain things. I want you to take the right steps and realize that it's really a difficult situation, but many, many, many people can get through a second offense DUI with reduced charges, with limited to no jail time, or totally unscathed with a dismissal with deferred prosecution. So hopefully you found this helpful. If so, please like and please subscribe. More people get the help they need. More importantly, if you get a legal problem in Washington State, a criminal matter, feel free to give my office a call. We've been doing this for more than 20 years. We get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.